Ghost guns. Of course, we know there's no such thing as ghost guns. That's a propaganda term by the anti-gun lobby that's made up to talk about you and I making our own firearms, do-it-yourself kits and do-it-yourself firearms because we have a constitutional right to do so. Don't believe me? Well, you're going to believe Stephen Halbrook, one of the most famous Second Amendment attorneys in American history, who's been cited repeatedly by federal courts, including by the United States Supreme Court. He's going to talk in detail about the so-called ghost gun regulations, the ghost gun litigations, what's going on with the ATF on related topics. Stay tuned. You're not going to want to miss this. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and yes, best-selling author. If you have not subscribed to the Four Boxes Diner Second Amendment channel, please do so and help us grow this channel. And note, I'm also on Twitter now. Believe it or not, we have to do the social media thing to grow the channel, and therefore I'm making that sacrifice. So, Stephen, I want to talk about ghost guns, which, as we know, is a propaganda term by the anti-gunners for, guns that are homemade, do-it-yourself guns, self-made guns, whatever you want to call these things. And of course, we know it's a propaganda term because Americans have had a long-standing, not just a right, but a tradition of making their own firearms going all the way back to even before we were a country. So before we get into the details of what the ATF is trying to do with so-called ghost guns, can we just step back, Stephen, since you're one of the foremost experts on the Second Amendment and the history of the Second Amendment, do we as Americans, under the text, history, and tradition of the Second Amendment, do we have a right to make our own firearms in our basement, do-it-yourself stuff?
The original settlers in places like Jamestown and Plymouth Rock, they brought guns from England. Over time, they imported gun parts and made their own guns to some extent. And then the German immigrants came, and they were excellent gunsmiths in Pennsylvania in particular, and they started making rifles, long rifles that were very accurate, very high quality. They made pistols. And so it was a cottage industry. You could make your own gun. You would have craftsmen who would make guns. When we had our revolution, that was a big deal to get guns. We got them from France. We made them any way you could get them. And there was always this tradition. It's never been restricted in United States history against making your own gun. And to this very day, that continues to be the case. Now, you suddenly have restrictions in a few of the usual nanny states against so-called ghost guns, which is nothing but a propaganda term, meaning that they prohibit pieces of metal that are not machined fully, but are partially machined so that you can make your own gun. And so, in terms of federal law, there is now this ATF regulation that has come into being about so-called firearm kits and frames and receivers and whatnot, where they're trying to restrict the sale of these different kinds of parts and raw material to make it more difficult to make your own gun. But you can still make your own gun, and you don't have to serialize it under federal law. There's no restriction still on making your own gun. There's just now a new regulation that restricts your access to the parts and raw materials from which you can make and assemble a gun.
So under the Second Amendment's right to keep and bear arms, we got to, if you think about first principles here, Stephen, we have a right to keep, which means to possess, and the right to bear, which means to carry guns in public, right? We have that right. It's in the text. The Supreme Court has confirmed this repeatedly. So it seems to me that if I have a right to have guns and I have the right to carry guns, it seems like I, by impliedly, have the right to make my own guns. Like there's nothing about the Second Amendment that requires that I go out to somebody else and buy a gun. It seems to me that I have the right to make my own gun if I have the capability of doing so. And that seems to be a long-standing American tradition going back to before the American Revolution. Is that all true?
Well, absolutely. And even if you were required to go out and buy one, somebody had to make it to start with. And so you have a right to make your own. We also have manufacturers. We have Colt, Smith & Wesson, Springfield Armory, big companies that make guns. They have to be licensed by ATF, and that comes under supposedly the commerce power that Congress has exercised. But in terms of making your own, there's no no federal law restricting that. And it's your right. There's an implied right, if you can keep and bear arms, obviously, an implied right to make arms. Just like there's the right to free press. You couldn't say that it's disallowed to make your own press, whether an individual or a newspaper, consistent with the First Amendment. You have that right to do that.
And then so that's helpful, I think, to the audience to understand that's the constitutional level. And as we all know, the Constitution is the ultimate, the highest authority, and anything that conflicts with it is not acceptable law in American life. So that's the constitutional component. But now let's go down to the federal statutory component. So issues associated with who is allowed to make firearms really does in part turn on whether or not you're trying to make money. So as I understand it, Stephen, if I just want to make my own gun, I'm allowed to do that in my basement right now under federal law, perfectly legal. But if I want to go into the business of making firearms and selling firearms to make a living, to make a profit in commerce, now I become a business, and under federal law, specifically I think it's the Gun Control Act of 1968, now I am now required to go get a license and do certain things and jump over certain hurdles and go through certain hoops with the federal government. Can you talk a little bit about the difference between what I'm allowed to do as an individual making my own gun just for myself versus what a gun company, gun manufacturer has to do if they're in the business of making firearms for other people?
Right. Under the Gun Control Act, if you're engaged in the business of manufacture of firearms, you have to get a license from ATF. Engaged in the business means that you have repetitive activity of manufacture of firearms for profit, and not as part of a hobby or a collection or whatever. And so that excludes people who make their own guns, and you could occasionally sell your own guns that you might make, but if you're not doing that repetitively for profit, then you're not included in the requirement of having a manufacturer's license. So if you get a manufacturer's license, you're subject to ATF inspection. You have to keep records. You have to do traces occasionally, and the premises have to be accessible under certain circumstances to ATF inspectors to inspect inventory and required records. So that's a big deal. I mean, if you get that license, you are subject to these many regulations. But if you're not required to have a license, then obviously you don't have to keep records. You don't have to serialize your firearm if you make them for your own personal use. And other than that, you're free to go. It's no different than making your own whatever else.
Right, it's a do-it-yourself process. So I think this is very important for people to understand, to talk about this new frame and receiver rule and some of the ghost gun rules. To start out with the extreme. On the one extreme, if you're just making a gun for yourself, that's constitutional. You can do that, no big deal. If you're manufacturing guns for other people for profit and you're doing it repeatedly, then you have to get a special license. So once again, it seems like now when you talk about these so-called ghost guns, we're sort of somewhere in the middle here. And correct me if I'm wrong, but the way I thought one of the big issues here is, well, I mean, I know I'm not particularly competent when it comes to making things. I can do certain basic things, but I'm not going to construct a house by myself, for example, or anything like that. I'm not that competent. So it seems to me when we get into this ghost gun issue, what we're really talking about are people that make sort of potential parts or aspects of parts or parts of potential firearms, and they're able to sell them to people so that people that are not as handy as like others can still make their own firearm, but they don't have to literally do it from scratch, which would be kind of absurd to have to do everything from scratch. So is that, do I get this about right? Or what exactly is this ghost gun issue where we know at the one extreme you have to get a license, at the other extreme you can do it in your basement for yourself? Where are we in the spectrum or this continuum when it comes to ghost gun fights in America today?
So there's a lot of hocus pocus going on here. The Biden administration says, well, we have banned ghost guns. Well, they haven't done anything of the kind. That's just to satisfy their base by saying that. First of all, you can make your own gun without restriction. Does it have to be serialized? Only if it goes through a licensed dealer, a federally licensed firearm dealer. But here is where the vice comes up, where the squeeze comes up. I want to read two definitions that they have adopted in their regulations to try to limit your access to the materials, raw materials and parts from which you can make your own guns. I want to get this right, so I'm going to read this. They redefine frame or receiver to include a partially complete, disassembled, or non-functional frame or receiver, whereas Congress only said a frame or receiver is considered a firearm, but not a partially made one. And what they've also done is to try to put in a definition of firearm to include a weapon parts kit that is designed to or may be readily completed, assembled, restored, or otherwise converted to expel a projectile. So they made that up. Now what they've done there is taken phrases from other definitions in the Gun Control Act. For example, a frame or receiver. It has to be a frame or receiver to be a firearm. ATF has tried to adopt a regulation to say, well, if it's a so-called, they don't use the term 80% receiver, but that's commonly used. It's not yet a frame or receiver, and they're saying that it is. And by the same token, a firearm is redefined in the regulation to include a collection of parts and maybe an 80% receiver. And of course, Congress never said any such thing. And what we're ending up with is ATF trying to restrict so-called ghost guns by restricting access to the raw material and parts from which you can make your own. And that's where they've gone beyond what Congress gave them the ability to do so. So we have a case out of Texas, Northern District of Texas, called Tactical Machining versus ATF, where the court just decided that those regulations are invalid. ATF has no authority to do that. There's another case, however, out of the, I believe it was North Dakota Federal District Court, which upheld all of that, those regulations. So there's going to be a lot of litigation coming up, and it's going to come to a head. I expect there'll be litigation in different district courts across the country. These decisions by whoever loses is going to appeal. It's going to be Court of Appeals decisions. Maybe it'll work its way up to the Supreme Court. We'll see. The Supreme Court does need to decide and to apply to more topics, like it just did in EPA, the West Virginia versus EPA case, that if something is a major issue before the public and an agency is just trying to shoestring some vague language where they have authority to do something, if it's a major issue, they cannot do that. They cannot decide a major issue on their own with some extensive construction of a statutory authorization to do something. And so that's where we need some clamping down by the courts, in particular the Supreme Court. We need clarification and overruling of the so-called Chevron deference doctrine, where courts defer to the government's interpretation of laws when the courts are supposed to decide the law, not agency. You don't defer. You don't give your power to the executive branch to determine what Congress meant when it passes laws.
So it seems to me, to break that down a little bit, just so people understand, I know a lot of people on the channel understand this already, but just to be clear, when we talk about a firearm frame or a firearm receiver, these are terms that are actually in the Gun Control Act statute. Is that correct?
Right. Firearm is defined to include a weapon that shoots or may be readily converted to shoot or is designed to shoot a projectile, or a frame or receiver thereof.
Now, a frame is usually the word we use in terms of the sort of the outline, if you will, of a handgun, and a receiver. I know there's two parts, kind of, but a receiver generally refers to long guns and rifles. Is that fair to say, Stephen?
Well, frame or receiver, when Congress passed those terms, it didn't distinguish types of guns. Neither did ATF in its original 1968 regulation. In its most recent regulations that just became effective, it applies frame to to handguns and receiver to rifles and shotguns. It's somewhat arbitrary. It's harmless. I don't object to that, but that's the distinction that ATF is now making. Yes.
Now, how it seems to me what they're doing, Stephen, is they're confusing, and you won that huge ATF case, the Thompson Center Firearms case, and I thought in Thompson Center Firearms, one of the big issues there was they were talking about parts of a gun versus the actual gun. Does Thompson Center Firearms, is that going to play a role perhaps going forward in what happens with these so-called ghost gun cases, and what is a frame and what is a receiver?
Well, once again, we start even before we talk about that case with the principle Congress makes the laws, and certainly they make the criminal laws. And you have a tradition that, a traditional rule of interpretation that any ambiguity in a criminal law is construed against the government. So the rule of lenity is one way of phrasing that rule of interpretation. And so that Thompson Center Arms is the case in which the Supreme Court applied the rule of lenity to ambiguous NFA definitions. And so, yes, that will be an often cited case in future litigation on all of these issues.
So right now, Stephen, there's a lot of talk about the authority of these regulatory agencies, including ATF. And I think it makes sense for the audience to be reminded that the ATF is part of the Department of Justice, which is in the executive branch. They're supposed to be enforcing the laws and not making the law. Congress is supposed to be making these laws. There seems to be some pushback on this deference to administrative agencies, in particular trying to undercut the so-called Chevron doctrine. This may play a huge role in the future of the authority of the ATF, because the one area in American life where the administrative agencies seem to really go crazy in making up the law is the ATF, and also, of course, the EPA, but we're not going to get into environmental stuff right now. But it seems to me that if you cut back on the authority of these administrative agencies to make it up as they go along, that's going to really cut back dramatically the ability of ATF to engage in gun control efforts. Is that fair to say?
Look, if that happens, it means they have authority to administer and enforce the Gun Control Act, including the National Firearms Act as well. That's what Congress told them to do. Congress never told them to make stuff up as they go, and that's what we've seen exploding since the Biden administration came on. I mean, frankly, we had the start of that in the Trump administration with the regulation involving bump stocks. That was the first time ATF had done that, to actually redefine a term that Congress had defined and to expand it in the regulation. But this is where we're headed, and there's been judges who have objected to that. Even judges that might normally rule against gun owners have problems with this idea that we are the court, but we let the agency tell us what the law is. That's a very dangerous doctrine, and with the Chevron doctrine, it started out being, if the law is clear, that ends it, the courts apply that. But if it's ambiguous, then we defer to the agency. And then, do you defer to them about everything? Like, do you defer to ATF when it decides, makes a classification that something is a short barrel rifle or just a handgun, or do you defer to them and their interpretation of their own regulations? So there's all these different strands of the Chevron doctrine, but the Supreme Court needs to just shut the door on this madness. They need to overrule the Chevron doctrine, and they need to apply the major question doctrine, which they just applied in the EPA case, more broadly to include other agencies, including ATF.
There's a lot of optimism that the Supreme Court might very well be doing this, because, as we know, I think there's 2 bump stock related lawsuits that are pending before the Supreme Court up on whether or not they're going to be granted cert. And those have been pending for a very, very long time, which seems to suggest the Supreme Court or someone on the Supreme Court is looking very carefully at those. So we may very well have a very exciting term for the ATF coming up, in October, but we still don't know that yet. But there seems to be some strong indications the Supreme Court is taken the ATF's authority and the Chevron doctrine's rule quite seriously, whether or not there needs to be a change made.
One of two things might be going on. As you say, the court has been holding several cert petitions on the bump stock issue. I don't think the court's particularly interested in bump stocks per se, but certain justices are certainly interested in the Chevron doctrine and major questions doctrine, and to the extent to which agencies can go beyond the statute. So the Supreme Court could grant cert in one of those cases and actually hear it on the merits. Or sometimes the court will hold cases because one or more justices wants to grant cert, but there's not enough votes to do that, but they want to write a dissent from denial of the writ of certiorari. So there might be an opinion by Justice Alito or Justice Thomas explaining why the bump stock regulations are unauthorized and why the court should take on the Chevron doctrine and overrule it. And that paves the way for certain justices to express strong opinions as to the merits of those cases without the Supreme Court actually deciding those cases.
Now, Stephen, going back specifically now to the framer receiver ghost gun issue. We've talked about you have the right to make your own gun. We've talked about how if you're a manufacturer of firearms, you have to register yourself. And one of the things you have to do if you're a manufacturer of firearms is whenever you make a gun, you have to put a serial number on it with some other identifying information about the gun. But if you make your own gun, as I understand it, you don't have to serialize it or put any identifying marks on it whatsoever, which is where the anti-gunners came up with the phrase ghost guns to say, hey, any gun that doesn't have a serial number on it or identifying mark as to where it came from is a ghost gun, which would include everyone that has every gun made under the constitutional right to keep and bear arms, as well as guns that have existed presumably, back before they had serial numbers in the early part of the 20th century. So I guess the question is, Stephen, where do these so-called ghost gun kits, these gun part kits come into play? These 80% receivers, which means it's kind of a lump of metal that with a little bit of work with maybe with the CNC machine, you can put some holes in it and then convert it into a gun. Where do these so-called gun part kits, these 80% receiver kits, these kits that people sell with instructions about how to make your own guns, where does all this play out in terms of the right to keep and bear arms, as well as the regulatory authority that the ATF may have under these statutes?
Well, first of all, a little walk in history. There was never a requirement of a federal firearms manufacturer license or of serialization of firearms until the Federal Firearms Act of 1938, and that required serialization of handguns and rifles, excluding .22 caliber rimfire. And it was not until 1968, the Gun Control Act of '68, that all firearms had to be serialized. All firearms that were made by licensed manufacturers, that is. To this very date, it's not required to serialize your firearm if you make it yourself. You might want to have a special serial number, like you might have your initials and your birth date, and that way if the firearm went missing, you would have evidence of your ownership of it. But you don't have to. And it's not a major problem. I mean, most criminals get guns that are made by manufacturers. They steal them. They get them on the black market. There's been these prison surveys by government researchers that prove that. It's not so-called ghost guns don't figure very highly in terms of criminal misuse. For one thing, criminals want reliable guns, and I don't know about you, but if I was a criminal, I'd like a gun made by a reputable manufacturer, not something that's just some knockoff by some individual. So there's also the question of, do they work? Like when you have an 80% receiver and you put it in a vise, are you going to drill the holes in the right places? Are you going to do the milling in the right places? Is the darn thing going to work? Well, not necessarily. So once again, this hasn't come to a head in terms of Second Amendment litigation, but I can see that in the future. These states that ban making your own gun, for example, they ban the distribution, of so-called 80% receivers in their states. They have shaken down for civil penalties, monetary fines, companies that have sold products from out of state in their states. And so this is going to be coming to a head in one way or another.
By the way, Stephen, even though you have a constitutional right to make your own gun, you're not allowed to make a machine gun or any of these guns or weapons that are fall under the NFA, I believe, right? In other words, you're not allowed to make an NFA item because that would run afoul of the NFA. So you can't make your own machine gun. Is that accurate?
Well, just machine guns. That doesn't apply to other guns. If you want to make a short barrel rifle, all you have to do is file an ATF Form 1 with ATF, fill out certain information, send in your fingerprints, include a check for $200, and in a few months you'll get approval to make a short barrel rifle or a suppressor or a short barrel shotgun or whatever. Machine guns are different because in 1986 Congress passed a law banning any new machine guns other than for government use or for export. So machine guns, you cannot make your own machine gun, but you can make the other NFA firearms, and many people do that. You can file your Form 1, get a authorization by ATF to make a short barrel rifle, and then you can order a barrel that's short, under 16 inches, and put it on your long barrel rifle.
So, Stephen, this has been really helpful on the ghost gun issue. I'm sure we'll be talking to you more about this. There's a lot going on here, a lot of moving parts, a lot of confusion out there. And, this is a story we're going to stay on top. But again, thanks for talking to us about ghost guns.
Yes, sir. My pleasure.
Okay, I hope you learned something here at the Four Boxes Diner from Stephen Halbrook about the ghost gun issue. If you haven't subscribed, please do so. And again, we'll see you next time here at the Four Boxes Diner.
Orders up. Table 2A.